business before this court, draw near to the attention, you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. We have two cases on the calendar for this morning. The first case is Florida Elections Commission versus Blair. Counsel, you may proceed.
Good morning. I'd like to reserve 2 minutes. 3, yes, ma'am.
How many?
3.
Okay.
Very much. Good morning. For the record, my name is Ed Telechia, and I am a Senior Assistant Attorney General, and I represent the Florida Election Commission. I'd like to disclose something right from the beginning, that the brief that we have filed has one error in it. We reference to 120.57 subsection 17, saying that statute was amended in 2007 just to add the word explicit or explicitly. That is an error. That is not correct. The entire provision, 120.52 subsection 17, was added in 2007. Substantively, I don't believe it makes a real difference in this particular case, but I wanted to disclose that up front. I didn't catch the error until after it was filed, after the brief was filed. But with that said, I'd just like, this case involves Rule 2B 1.002 of the Florida Election Commission, and it's the rule that defines the term willfulness for purposes of willful or willfulness for purposes of determining whether a candidate violated Chapter 104 or 106 of the Florida Election Commission, of the Florida Election Code, excuse me. It's a predicate element. In other words, before they determine whether the person, actually can be charged or can be fined or anything, they have to determine whether the violation was willfulness.
Well, the violation that Mr. Blair was charged with, 106.19.1a, requires it to be knowing and willful, doesn't it?
That is correct. It says, well, according to what the definition is of willfulness as it appears in the rule.
I'm talking about the statute itself. As I read 106.19, it said to be a violation, it's got to be a knowing and willful acceptance of these campaign contributions. I mean, does that make a difference for purposes of our review of the rule here?
I don't think it makes a difference, and the Election Commission does not believe it makes a difference for these purposes. It looks at when we look at the definition of willfulness and knowing willfulness, we look at it together as with the definition that we provide to willfulness, we give it to the entire provision when it says knowing and willfulness. There's a position of the Election Commission that there is statutory authority for this, that it is a specific and explicit grant of rulemaking authority in 106.21, subsection 1, that says the Commission shall, pursuant to rules adopted and published in accordance with 120, consider all sworn complaints filed with it and all matters reported to it by the Division of Elections. When you read that in conjunction with 106.25, that requires that they be willful, that, willfulness is a predicate element, read those together, we believe that there is sufficient statutory authority for that rule. Now, this rule was previously challenged when the definition applied, when the rule strictly applied to Chapter 104, and it was challenged in ADOA in Oliphant versus the Florida Elections Commission, and it was upheld by the administrative law judge. And that's basically the analysis that they looked at. And then also, and if you look even farther before that, in the Fugate Court, which is the First District Court of Appeal, this was a case that involved a situation where the Florida Election Commission found a willful violation of Chapter 104 against Mr. Fugate. They applied the definition as it appeared in the statute at that time, on 106. And the court basically told the Election Commission that they could not use the definition in 106 for purposes of 104 violations. This was before we had the rule. But it said, it wasn't dicta, but it did say that...
It was not dicta?
It was in dicta. It did say that you could have a rule defining willfulness for purposes of 104, but you don't, so we're going to go ahead and impose our own definition. So that was the Election Commission's position on this particular rule. And when the statutory definition of willfulness was removed, we went ahead and added 106 to the rule that we had for willfulness, so that willfulness would be defined for purposes of both 104 and 106.
Well, what's the difference in the rule definition and the common law definition, or is there a difference?
Well, there's been a couple of different definitions, in the common law. There's what we refer to as the civil standard on the Election Commission, which is the reckless disregard standard. And that's what we've used for purposes of our rule, and which used to appear in Chapter 106, in the Chapter 106 definition. And the other one is the what we call the specific intent standard, which is commits the act voluntarily and intentionally with specific intent and bad purpose. This, it's, if you look at the case law throughout, throughout history in both federal law and in state law, they're both used, but it's not defined. Well, not anymore. It's defined in statute, but it's for different purposes. It's defined differently. Usually, the specific intent standard is usually used for criminal law purposes, but not strictly. But it's usually in criminal law, and the reckless disregard standard is in civil cases. In some states, they do have the specific intent standard for election commission violations, but Florida has not been one of them. In this particular case, the administrative law judge, it seems like, he's basically saying that there is no explicit statutory authority to define willfulness or willfulness that can be read in the clear statutory language. And it seems like his ruling is based on two premises. And the first one, it seems that he's saying that the addition of section 120.52 subsection 17, where they define rulemaking authority now, it seems like he believes that further restricts the agency's rulemaking ability to now require detail in the enabling statute as to the subject of the rule. And this has never been, the courts have never interpreted rulemaking authority in such a way before. And he, quite frankly, he cites to no legal authority for this proposition at all. There's no case law.
Let me ask you, it's interesting that you have a rule that applies to Chapter 104 that's not being challenged here, obviously, but only as it applies to 106, correct?
Well, in this
is a 106 case.
That's correct. This is a 106 case.
So you have a rule that defines willfulness in terms of 104 that this Court seemingly encouraged you to adopt, or certainly in dicta said that it would be appropriate. The legislature has, you pattern that definition after the rule definition, after the statutory definition, correct?
That's correct, yes, sir.
So it's,
with a few improvements.
You have a 104 definition that is almost identical to the statutory definition in Chapter 106. And, anybody involved certainly with criminal law knows how critical it is to define willfully, but certainly in the civil context as well. So you have this definition. It basically mimics the legislature's definition. And then the legislature eliminates the definition.
Yes, sir.
Does that seem to you to lead into the appellee's argument that where the legislature speaks and says, we no longer authorize this definition, how can the agency have rulemaking authority to adopt it by rule?
Well, generally, I would agree with you that it raises the big question. In this particular case, the legislative record is completely empty of any...
Well, I'm just talking about the text.
Okay, well...
I'm just talking about the act. The legislature has this very detailed, and I can understand the agency using it, and I think it's commendable. But they have a statutory definition of willfulness. You mimic it in your rule, and you had previously used it, which seems certainly appropriate, And then the legislature comes back and, for whatever inexplicable reason, eliminates it.
I agree, but
and
they
does
did
not seem to say, at least if there's anything implicit from that act, is there not a good argument that the implicit statement by the legislature is you shall not use this definition? Well,
there is an argument, but I wouldn't argue that it's a good argument, and I'll give you the reason why, Judge Thomas. Because the legislature did not replace that language with anything else. It left us with nothing. And because there are multiple definitions for the term willfulness, we would have to go ahead and apply it on a consistent basis in each case. We can't decide as...
Yeah, you made the due process argument in your brief, and I can understand the power of that argument, but I assume the appellee, and certainly in this case, would take the tack of, appreciate your concern for my due process rights, but I'm not concerned about that right now. I'm concerned about the rule. Mm-hmm. And so due process isn't really an issue here, is it?
Well, I disagree. I think it is an issue here. And it's not just for this appellee, but, of course, for the future cases that come before the particular board. And before the commission, excuse me. And we also have to keep in mind that, we presume that the legislature knew the judicial construction of this rule and of these statutes in the past. And, and in particular, these legislators, because they are the regulated entity by this rule. So we know they're familiar with this rule and what's happened with this particular rule. And, there's four things that we can presume. One is that we knew that they knew about the legal construction of Chapter 106 in the past. And when they amended it, we can presume that they knew that the Commission was using 106.37 for both 104 and 106 104 and 106 complaints prior to 2006. I think we can also presume that they knew about the Fugate Court invalidating the definition. And after the fact, the Election Commission promulgating that rule for purposes of Chapter 104. And then they should know about the rule challenge also in the Oliphant case where it survived the challenge.
So your argument is it's just as good an implicit argument that the legislature's simply deferring to your definition?
Absolutely. They knew about all this, but they didn't change the rulemaking authority. They left all that language that was in place before that we use for our rulemaking authority for purposes of Chapter 104, and they just left it in place. So if it was good for purposes of Chapter 104 complaints, it should have been, certainly it's good enough for purposes of Chapter 106 complaints, being that that specific language is found in Chapter 106. So the fact that they didn't touch any of that, by the same token, I think it creates you can say that they implied that, all right, you have a rule, fine, we don't need the statute. If they really wanted to change the definition of willfulness, they would have put it in a different statutory provision, or they would have changed the definition in 106 or 104, or they just would have said, we're taking away your rulemaking authority, and you're going to have to deal with it. And then willful would be ambiguous, and being that these are penal statutes, they would have given the definition that would have been to the benefit of the respondent, and you probably would have used the specific intent provision. But they didn't do that in this particular case. The other thing is, it seems like the administrative law judge in this matter is also putting a great deal of weight on this new language in 12057 subsection 17, this explicit language. And we are in the position that this does not change rulemaking authority. The case law and rulemaking authority as it applied to the flush left language in subsection 8 of the same statute. It's never been defined like that before. And quite frankly, it's, the record for those amendments to 120 for
Let me shift your attention to the law implemented component, where the ALJ seemed to say that the statute is inconsistent with the legislative act of repealing the statutory definition, which is kind of confusing to me. But when I kind of bored down through it, I think I finally figured out the law being implemented is whatever it is, 25 per N 3, and there's or whatever the statute is, correct me if I'm wrong, and there's a provision there that said willfulness is a determination of fact.
Yes.
So isn't that the law being implemented that we really have to focus on to see whether this rule, by defining willfulness, is inconsistent with that language?
Well, it's not inconsistent. That willfulness is...
But isn't that the language? I mean, the fact that they repealed something is, it can't be inconsistent with something that isn't on the books, can it?
Well, I agree, but that language, that willfulness is a question of fact. It doesn't mean that the way we define willfulness is a question of fact. It's basically codifying what the Fugate Court said. Before that, the Election Commission they overturned a willfulness finding on a recommended order improperly, before I represented them, by the way. And they said that willfulness was a question of law. And so went to the Fugate Court on appeal, and they properly, chastised the Election Commission and said, no, it is a determination of fact. In other words, whether the respondent committed the act in a willful manner is a question of fact, but not whether the definition of willfulness is a question of fact. That's a question of law, and it has to be consistently applied in every particular case. You can't decide on a case-by-case basis, based on looking at the facts of the case, whether, how we're going to define willfulness in this particular case.
So your argument boiled down to the essence on that is the fact that the legislature has said that the determination of willfulness is a question of fact is not inconsistent with a legal definition of willfulness.
Absolutely. I agree 100%. It is not inconsistent at all whatsoever. In fact, that language about willfulness is a question of fact. It really has nothing to do with this whole rulemaking issue. like I said, it's a codification of...
Except the fact that that is in the statute.
It's in the
that
statute.
the rule purports to implement.
That is correct. That is correct. But I have very little time left, and I want to keep it for rebuttal, so I'm going to go ahead and finish this time, okay? Thank you very much.
Thank you.
Good morning. It pleases the Court. Emmett Mitchell for Brian Blair, the appellee. I think Judge Thomas and Judge Weather, you've touched on the key to this case. The legislature repealed the definition of willfulness in 2007, and as you pointed out, it also added in to clarify that willfulness is a determination of fact. The third prong of the change that it made was that it removed the Commission's authority to issue final orders. So now we take the position that the Elections Commission this is just a continuation of the Elections Commission's attempt to hamstring the administrative law judge in his or her fact-finding.
How does having a legal definition of willfulness in any way hamper the ALJ from making factual findings and then applying that legal definition?
Well, I mean, the argument that the Commission is making is that the ALJ can continue to make findings of fact and then determine whether they fit in within this legal definition that the Elections Commission has created. But I think that goes against the intent, the clear legislative intent of the 2007 changes when they deleted the definition. The Commission
What do you think the legislature meant to do? You talk about these three prongs, and that's an interesting point. They eliminate the definition. They declare that willfulness is a finding of fact. I'm not sure what impact it has to say that the Commission doesn't issue the final order, but what do you say in response to your opposing counsel's argument that, gosh, this is an implicit recognition that our rule definition is working fine, and we can just continue to apply that?
Well, I think that, there's a history here with the Commission. As this Court knows, the Commission operated without a rule or a statute back in the 90s and worked fine with it. The definition came in 1997, I believe, the definition for willfulness. And what the Commission did for several years is take the ALJ's findings and decide, if it didn't agree with the decision of the ALJ, that it didn't meet the definition that the FEC had created. I think this is the case on a number of occasions. The Elections Commission would simply say that these findings are a conclusion of law. The case would be appealed to the first DCA, and on every single occasion, the Elections Commission lost. We take this as just a continuation. After the legislature repealed the definition, they began rulemaking several days after the law was enacted, in time for the rule to be in place before the repeal was effective on January 1, 2008. We see this just as a continuation of that effort.
Let me ask you a practical question, because as I read your brief, where you talked about the varying definitions of willfulness in the Fugate Court and then referring to a Metropolitan Dade County Court case, if I read your brief correctly, you seem to be saying that assuming the rule didn't exist, that the willfulness would get the same definition it's getting in the rule. I mean, did I misunderstand what you're arguing there? I
think it probably would. I think the rule itself, the content is okay, but I think that goes to my point that we don't need a rule. Never have. The ALJ knows what the standard is, and they've been using that standard before they promulgated the definition and the rule.
Well, then why is this case here, I guess? I mean, I know why it's here, but it makes, I mean, we're talking about two alleged violations for above $500 campaign contributions. We have case law out of this court now saying that the ALJ can't even recommend or impose a fine, and you're telling us that the definition that the ALJ would apply in that case is the same definition he would apply without the rule. So what's the point of this rule challenge?
I think we're trying to make the point that the legislature made some specific changes in 2007 and 8, and the Elections Commission has basically thumbed its nose at the legislature.
So even if they're using the same, even if the ALJ were to use the same definition as contained in the rule, your argument is under Chapter 120, without the specific authority, you can't have the rule regardless.
Correct. I think if you set aside the legislative changes, I still believe under the authority that they're citing to in 106.261, they have the specific authority to consider sworn complaints. And they've already promulgated 2 rules that deal with hearings before the commission and considering complaints in the initial process. Those rules have been on the books for almost 20 years. And to suggest that 106.26 sub 1 gives them rulemaking authority for this definitional rule, I think is not consistent with the Day Cruise decision or the Save the Manatee Club decision.
Well, as I understood what the ALJ was saying, is he acknowledged those decisions where we said the question is whether you have specific authority, not whether it's specific enough, essentially seeming to bless a view that the statute doesn't have to basically restate the rule. But then the ALJ, after acknowledging those, the ALJ then says, well, the legislature's adopted a new statute which uses the term explicit. And, you know, do you interpret what he said, and is your argument that that new statute now imposes further restrictions on rulemaking?
I do. That coupled with the Lamar decision and those 2 cases in particular, Save the Manatee and Day Cruise, I think that further restricts an agency's rulemaking authority.
So your argument would not be without the, let me try and rephrase that to be a little more clear. If the rule is declared invalid, if the ALJ is upheld by this court, would a subsequent litigant be able to argue the definition of willfulness as specific intent with bad purpose, the higher standard?
I don't believe so. I think it's just a reckless disregard standard. And I think that's the standard that the commission had adopted for years before they had the rule in place. I don't think...
So your argument boils down to, I guess, the legislature has very clearly said we do not want rules that are not authorized by this body, period. Whether they're good, bad, indifferent is immaterial. If it's not explicitly authorized by the legislative body, by the legislature, you're not going to have that rule.
Pretty much.
Even if there's no negative consequence, as in this case.
Well, I think, you know, in the specific authority they have here, they've got rules in place. And I don't think you want to set the precedent that an agency can go out and adopt any rules it wants to simply because there's no downside to their adoption. I think the...
Well, your argument is, I take it, not that we would say that, but that the legislature has said that.
Well, and I don't think the way the commission is interpreting these legislative changes, that this is somehow an invitation to rulemaking. I think that's entirely incorrect. I think the legislature was clear in what it did. We all know that in the waning days of legislative sessions that often details get missed, but I think the legislature was pretty clear that they wanted the commission to do without some kind of definition either in statute or rule for willfulness.
What, if I read the ALJ's order correctly, he says, seems to kind of boil down on the authority question, that there's no, quote, explicit, unquote, statutory authority to define willful or willfulness that can be read into 106.26. What what would the statute require? Would it require something that said the commission shall adopt rules to define terms in this? Would that be explicit enough, or does it need to go further and say the commission shall define willfulness?
Your point is well taken. I think 106.26 to have the requisite authority would probably say something like the commission shall adopt rules to establish the standard of conduct in Chapter 104 and 106 cases. Something other than simply consideration of complaints. There's no mention of willfulness in this specific authority at all.
Well, isn't that true in most statutes that authorize rulemaking? It just simply says something to the effect of the agency shall adopt rules to administer this chapter, and then you have to go elsewhere in the chapter to find what law they're being implemented.
Yes, you're absolutely correct. But we believe, I mean, this specific authority has been on the books for years, and it hasn't changed. I don't know why they've now adopted a rule when they had this same language in place for 20 years. And they've actually got two rules that they use to consider sworn complaints based on this particular specific authority.
So, in your view, what does consider mean? Is it, I mean, couldn't consider mean, the beginning of the process to the end of the process? They have to consider and dispose of these complaints in some manner. So why wouldn't their consideration of the complaint include the standard of which they're applying to it?
I think it could in rare cases. But once we took away the final authority for the commission, almost all of these cases, and I can't confirm this, but all the cases, if there's a disputed issue of material fact and willfulness cases, go to DOA. So the commission is never really ever considering any willfulness cases in a formal setting.
One other thing that struck me as kind of interesting, the ALJ invalidated this rule in its entirety. You challenged it, or your standing to challenge it was, I guess, limited to the fact that you have a 106 proceeding pending against you. We, in dicta, implicitly blessed their authority to adopt it in a 104 context. Even if we were to agree with you in all respects, didn't the ALJ grant you more relief than he should have, could have, and shouldn't it be reversed at a minimum to invalidate it only as it applies to 106?
Well, I think in the Fugate case, this court invited in dicta the commission to engage in rulemaking with respect to Chapter 104, but it never cited any particular authority for rulemaking.
That's not binding on this panel.
And it also
that dicta is not binding, correct?
And with all due respect, as you know, a court can't confer rulemaking authority on an agency. That's the legislature's job.
My question is more fundamental. You sought the invalidation of this rule, best I could tell from your petition, as it applied to 106. I mean, I don't think you would even have standing to challenge this rule as it applies to 104, would you?
Correct.
So the ALJ, as I remember, 12056 is authorized to invalidate a rule in whole or in part. By invalidating it in whole, it seems to me that he went beyond the relief requested in the initial petition here. And I guess so, I mean, maybe you disagree, but it would seem to me that at a minimum, all you were entitled to is a declaration that the rule is invalid as it applies to 106.
No, I think you're absolutely correct,
But the
Judge.
appellant hasn't raised that issue, right?
No. If there are no further questions, then I'll finish. Thank you.
Very, very briefly, the intent of rulemaking specifically is to let the regulated entity know what the regulator knows. And if we don't have this rule in this particular case, the regulated entity is going to have to guess. They're not going to know what we mean by willfulness unless a court somewhere could come down the line and...
Well, your opponent seems to imply that essentially the commission doesn't really have much of a role to play anymore in the finding of willfulness.
Well, that's not correct, because...
How is that not correct?
Because if you look at the statute regarding willfulness as a determination of fact, it says willfulness is a determination of fact, but you need to read the rest of it. It says, however, at the request of the respondent at any time after probable cause is found, willfulness may be considered and determined in an informal hearing before the commission. And that has occurred at least in one instance. So, yes, the Election Commission still has a role playing the determination of willfulness.
Let me ask you this, because that was a very persuasive argument to me that most of these cases are now going through DOA for final order rather than the commission. So the commission's consideration of these complaints may not necessarily include the final disposition. But let me ask you this. Does the consideration of the complaint, I guess, would include determination of probable cause, wouldn't it?
Absolutely. And you look at willfulness, determination of legal sufficiency and
So
determination
that
of
would be
probable
your
cause.
response to his argument that the commission's role in the process doesn't necessarily include, but for your one case, the adjudication of willfulness.
That's correct.
Gotcha.
That is correct.
Thank you.
All right. Thank you very much.
Thank you, counsel. Thank you both.